We learned new details Wednesday during the first public impeachment inquiry into President Trump. The top U.S. diplomat in Ukraine, Bill Taylor, revealed a previously undisclosed phone call involving President Trump. He also spoke about a witness who was previously not on anyone's radar. Rebecca Roiphe joins me now. She is a CBSN legal contributor and former New York Assistant District Attorney. Rebecca, thank you so much for being with us. So it was really interesting to see this format today, where you had two lawyers in those initial rounds of questioning, one for each side, the Democrats and Republicans, kind of go on their extended excavation of facts for their side. Talk to me about some of the benefits of that approach versus what we've seen in other hearings where you have 5 minutes on one side, 5 minutes on the other.
Yes, I mean, I think the lawyers have a different attitude, which is they're trying to get their story out and they're trying to get the facts out. And instead of also trying to grandstand and try to take political points, make political points, they're not interested in doing that. So you have a sustained narrative on both sides. And I think that helps the American public understand what actually happened instead of, sort of these sound bites where you kind of feel like everybody's self-interest is in the game and you can't quite figure out what happened. So I think it's very effective.
So how is their questioning? I mean, you alluded to it a moment ago, but how is their questioning different from what we see with members of Congress? Because it seemed like, you're right, there was this very sort of direct way in which they were approaching how it was that they were questioning these witnesses.
Right, because it's not about what they say, it's about what the witness says. The lawyer is trying to get the witness's story out. Now, of course, they're trying to shape the way the witness's story comes out. And that's, it takes a lot of skill and talent to do that well. But that's different from trying to get your own point out. And I think what you see time and time again with the different congressmen is it's about their spin or their story or their message they're trying to send either to the president or their constituency. And that becomes distracting.
So we heard a lot of back and forth today about whether the president's conduct regarding Ukraine was an impeachable offense. Break down for us, how exactly is that idea of an impeachable offense defined?
Right. So an impeachable offense is defined as treason, bribery, or high crimes and misdemeanors. Those are the words that are used in the Constitution. We know that what it isn't necessarily a federal crime or a state crime or conduct that amounts to crime at all.
You're not going to find it like at a statute.
You could. I mean, there could be overlap. It could be a crime, but it doesn't have to be. Traditionally, the concept has been abuse of power. The real sort of paradigmatic, impeachable offense, treason, bribery, there's a reason why those two things are named, because those are abuses of power.
So did you see anything with that in mind, anything today that was revealed that might actually be used as evidence or rose to that level of evidence potentially for articles of impeachment?
Well, I mean, I think the facts were very clear. I think one thing that happened during this hearing is that very few facts are being contested. There's a lot of argument about what this means, whether it's bad, whether it's good, but we pretty much agree on what happened. And so I think that first of all, I just want to say, I think that's a win for the rule of law. It's extremely important that our institutions be able to get facts out to the American public. There may be a few people who are saying we don't believe what happened here, but for the most part, we're fighting over what the import of those facts are. You have a Republican narrative that's saying no big deal. This was just kind of normal business. This is the president acting the way he does, which is doing things on his own, sort of, cutting away the bureaucracy, cutting away the deep state and getting stuff done. And then you have a different narrative on the part of the Democrats saying this is an abuse of power because presidents can do a lot. They have a huge amount of power, but there are limits. And the limit is the law. And here he abused his position for personal gain. And that is an abuse of power that amounts to an impeachable offense. So you have those two narratives put out there, and I'm just happy to see that there's one set of facts that we're arguing about, pretty much.
I mean, it is remarkable that you point that out, though, because it is true. In other debates, there is a dispute over what even happened and took place, but we're not necessarily seeing that unfold in these hearings.
Right, and in part, that's because we have these career civil servants that I think even both sides, even if it would be advantageous for you to say that they're lying, it's not working. And so you have to take a different tack if you want to say this is not an impeachable offense. You don't go for their credibility, or only a little bit, because you can't. And that shows that what sometimes cast as the deep state, actually no. People do trust that we need and have career officials who have been working and who have developed a knowledge, an understanding of some complicated political terrain like the Ukraine, and that's important, that we can trust and value those people. So that's come out of these hearings. And so whatever happens, to me, I think that's a win.
Yeah, it'll be interesting to see polling as this impeachment inquiry goes on and as there's more and more of this public testimony, how it is that people are feeling about it. So the president has argued time and time again that he is not receiving due process. Can you explain for us how these proceedings are actually meant to work and whether or not due process is a factor at this stage in the impeachment inquiry?
Well, yes, there are various different arguments that are going on. One is the Sixth Amendment argument that I think has no merit at all, because the Sixth Amendment really applies to criminal proceedings. These are not criminal proceedings. They're not even analogous to criminal proceedings. They are analogous to a grand jury investigation in which those protections do not yet exist. So in that way, no. Would he like a different process? Might there be a different process that would be more fair to him? Possibly.
But he wants to face his accuser,
right? And that will happen. That will happen at a later point. Well, I don't know if he'll be able to face the whistleblower, but you have a right to face the people who are accusing you, which means that once they build their case, once the Democrats build their case and they present it to the Senate, then he will be able to come in and face his accusers, whoever they are. However you build your case, you'll be able to confront those people just like you would in a criminal trial. But it's true that some of the protections are not at this stage here. And so he's suggesting that that invalidates the entire endeavor. I don't think that's right, because this is the way the endeavor has been done historically over and over again. I also think there could be, there could have been more cooperation perhaps on the process that would have made him happier about the way in which it's going. But it's very similar to the way in which impeachment has worked in the past. So it's hard for him to say, as he often does, I'm being particularly persecuted here. In fact, this is the way Bill Clinton was treated, Nixon was going to be treated. So it isn't unique.
So one of the things we've heard both the president and his supporters and Republicans say is that Ambassador Taylor's testimony is based on hearsay. Help us understand, do they have legal standing on that claim?
Well, first of all, again, hearsay is a concept that applies to a courtroom. And first of all, there are many exceptions to the hearsay rule. I think there's something like 23 in the federal rules of evidence of exceptions to. So just because you're not hearing from the very person who experienced something does not mean that it can't come into court. But again, the more important thing is we're not in court. And then the other thing that's kind of important to point out is that the president, the administration itself, is blocking the testimony of many of the people who have direct evidence. So it's a little bit ironic for them then to claim that the testimony is hearsay, because the Democrats have sought and tried to get more direct testimony and have been blocked in trying to do so. So to then turn around and be like, and this is secondhand evidence, this is the best we can do because we're not, the Democrats can do because they're not being given the opportunity to call witnesses who've had direct experience. And the documents, so both Kent and Taylor were saying that, we have contemporaneous notes, we put them in the file, the Democrats have subpoenaed them and have not been able to access them. That's very good evidence. Contemporaneous notes are considered excellent evidence to confirm the credibility of witnesses. So you would think that that would be important. And then the final point, nobody's really contesting the facts. So the idea that it seems to be kind of thrown out there to suggest that there's something unfair going on, but at the same time, nobody really is suggesting that this isn't what happened, the way that Taylor himself is lying, or that he's mistaken. And so that it again is, it's a useful argument, I think, on their part, but I don't think it's one of their better ones.
Yeah, no, it's really, it's interesting, again, to reflect on that, because in the past, that is what we would have seen, or we had sometimes seen, as a dispute over what actually took place. I do want to ask sort of a bigger picture here, because we're going to be having Marie Yovanovitch on Friday. We're going to have next week a number of days where you have more witnesses coming. Just as a strategy here, right? This is not a court of law. We know this is about the court of public opinion and trying to change minds. When you're trying to sort of present a case like this, is there a danger that perhaps there could be information overload as you're trying to present that case?
Right. I mean, and that's not that these are prosecutors, but that's a problem that prosecutors run into, because often in order to establish the elements you need to establish that a crime has occurred, or here to establish what happened that might be an impeachable offense, it's complicated. And one of the best moves of defense attorneys is to be like, oh my God, this is so confusing, reasonable doubt. And so, you know, so some of the Republicans' arguments were sort of along those lines. Again, not the ones that I think were the most effective, but a kind of you know, this is so confusing. Think of all of this, so very complicated. And what actually happened was just foreign policy as usual. Right? The money actually ended up going there, so no harm, no foul. We were just kind of, it was about corruption, and that works in a way, and I understand why it works, because the facts are a little bit complicated. Then again, the facts are a lot less complicated than the Mueller report. You know, this is not 400 pages. This is fairly simple. So it's the job of the congressmen, and ultimately, if articles of impeachment are voted, the managers who go into the Senate, to present the evidence in such a way that that you distill it down, you keep it simple, and that's, you know, how you're trained as a prosecutor. You have to try to keep it simple. And some of the Democratic congressmen did a very good job of that. Some of the others were like down in the weeds, and it, you know, and then you can just see it's playing into this narrative that this is just so complicated I can't follow it anymore.
Yeah, well, it'll be fascinating to watch how this unfolds. We'll have a lot more days ahead of us. Rebecca Roiphe, Rebecca, thank you very much.
Thank you.